Good evening and welcome to Courts Today by Livelaw. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. In an important update, the Punjab and Haryana High Court has observed that living together with another woman without dissolving the marriage from the earlier spouse may amount to offence of bigamy. These observations came in response to a writ petition filed by a live-in couple seeking police protection from the alleged threat by the relatives of the woman. They have been living in a live-in relationship since September this year, and their relationship has been accepted by the man's family, but not by the relatives of the woman. The police stated that they were getting death threats from the woman's family and hence needed police protection. While examining the plea, the court noted that the man was already married, having a girl child with his wife, and a petition for divorce from her was still pending before the family court. After considering the petition, the bench of Justice Kuldeep Tiwari concluded that only bald and vague allegations regarding the threats had been made without placing any supportive material on record to corroborate their allegations. Justice Tiwari also highlighted that the hidden intention of the petitioners behind filing this petition was to avoid any criminal prosecution in case of adultery. Accordingly, the court dismissed the petition. A plea has been moved before the Kerala High Court challenging the recent amendment introduced by the central government in the Surrogacy Regulations Rules of 2022. As per the new amendment, intending couples who want to undergo surrogacy can only use their own gametes and not donor gametes. Before the amendment, the rule permitted the usage of donor oocytes for surrogacy. The writ petition was moved by a middle aged couple who are unable to conceive naturally. As the petitioner wife was suffering from various illnesses and taking medications, she was medically advised not to plan a pregnancy or undergo any fertility treatments. The petitioner thereafter opted for surrogacy, but she was informed that due to ovarian failure, she was unlikely to produce oocytes from her own ovaries for undergoing surrogacy. The petitioner requires donor oocytes from another donor lady for undergoing surrogacy. However, due to the recent amendments, she is unable to do so. Thus, the plea challenges the constitutional validity of the new amendment as violative of fundamental rights and ultra vires to the existing regulations. It also seeks direction from the court to permit the petitioners to undergo surrogacy using donor oocytes. During the hearing today, Justice Devan Ramchandran sought response from the central and the state governments to know the purpose behind the amendment. The court admitted the matter and noted that it was a serious and important issue. The Karnataka High Court today directed the state government to give wide publicity to the guidelines regarding feeding of street animals and conflict resolution, which suggest participation of residents. The bench of Chief Justice Prasanna B. Varale and Justice Krishna S. Dikshit was hearing a petition filed by Ramesh Nayak seeking proper implementation of animal birth control rules. The court referred to the guidelines issued in December last year regarding feeding of street animals and conflict resolution, which refers to a substantial participation of residents. Some of the points under the guidelines include the responsibility of residents to ensure that all dogs in their locality are sterilized and regularly vaccinated by local authority, and that if anyone has a grievance with regard to any act of caregiver feeder in relation to feeding of community dogs, they must engage in dialogue and discussion through the Animal Welfare Committee. The court noted that the majority of citizens as well as residents were not aware of the guidelines and their responsibility regarding feeding of street animals. It said that unless steps are taken to make the public at large aware of guidelines, there shall be no effective implementation of the same. Thus, it directed that the state must give wide publicity to these guidelines in the official websites of the state government and explore other modes of public awareness. During the hearing, the state government informed the court that a meeting was called by the additional chief secretary after the High Court order to appraise the stakeholders about the order of the court as well as certain guidelines earlier issued, and that additional meetings were likely to be conducted. Under the leadership of Justice Chakradhari Sharan Singh, the Bihar State Legal Services Authority has unveiled the scheme for integration of transgender persons and their rehabilitation and providing access to justice 2023, that is SITARA. While taking initiatives for the holistic welfare of transgender individuals, the scheme aims to oversee proper implementation of the Transgender Person Protection of Rights Act of 2019 and Transgender Person Protection of Rights Rules of 2020. During his address, Justice Singh emphasized the key principles of integration, rehabilitation, and access to justice for the transgender community. Recently, a meeting was convened with various state government departments to discuss issues related to the identification, skill development, and housing of transgender persons. Moreover, Bihar State Legal Services Authority has officially recognized transgender persons as eligible for free legal aid. In another update, the Supreme Court has held that a judicial magistrate cannot entertain a protest petition against an order taking cognizance of a final report. In this case, a chief judicial magistrate took cognizance against an accused for the offense of murder based on a final report filed by the CID. The victim's father filed a protest petition taking objection that the magistrate did not take cognizance against other accused. After that, another order was passed by the chief judicial magistrate taking cognizance against the other accused persons. Then, the other accused persons against whom cognizance was taken subsequently filed a petition before the High Court against the action of the magistrate. Since the High Court rejected their petition, they appealed to the Supreme Court. The bench, comprising Justices Abhay S. Oak and Pankaj Mittal, expressed surprise at the magistrate entertaining a protest petition against an order taking cognizance. The bench stated that magistrate has no power to modify an earlier order taking cognizance. Thus, the subsequent order passed by the CJM taking cognizance against the appellants was set aside. The Kerala High Court today stated that the issue of dumping of waste, especially septic waste, into public areas and water bodies could not be taken lightly and requires immediate and urgent action. The court was considering the issue of septic wastage disposal in public places, especially in water bodies. Earlier, the court had directed that strict action would be taken against people who block drains by dumping waste and causing flooding of the city. The amicus curiae today informed the court about a mobile application called My Kochi, where there is an option for the public to post their grievances regarding septage waste collection. The app also has an option where public can make bookings for collection of septic waste. And the corporation can appraise the court as to how the app can manage the collection and disposal of septic waste and hotel waste. But the court was also informed that at present the application does not have all these features. Justice Livein directed the Secretary of the Cochin Corporation to verify the efficacy of the application and directed the Standing Council to submit a report regarding usage of application for the purposes of septic wastage collection and disposal. The court also issued various directions to prevent the dumping of septic waste into the water bodies. And lastly, the Punjab and Haryana High Court has granted bail to a man booked under the Unlawful Activities Prevention Act, that is UAPA. The court observed that there was no prima facie case made out in the case for allegedly planning to commit some terrorist acts based on relations with Pakistan. The court was deciding the bail plea of Guru Sevak Singh, against whom an FIR was lodged in 2020 under IPC, UAPA, and Arms Act. It was alleged that he was a part of the gang who was hatching plans to commit some terrorist acts in different places in the country. As per disclosure statement of the co-accused, they had robbed 30 kg of gold from IIFL Gold Loan Branch, Ludhiana. A division bench of Acting Chief Justice Ritu Bahari and Justice Manisha Batra noted that no specific role had been attributed to Singh to support the allegations of being involved in anti-national activities, that he had been in custody for about 3.5 years, and so far only 1 out of 38 witnesses had been examined. No recovery had been effected from him in this case. The court concluded that on the basis of allegations prima facie, no case could be stated to have been made out to presume that there had been any conspiracy to form membership of a terrorist gang. The court also said that the statute of UAPA has stringent provisions, but that makes the duty of the court to be more onerous. And it is well settled that merely because allegations were serious, on that reason alone, bail cannot be denied. I hope you found this video informative and enjoyable. If you did, please consider giving it a thumbs up and sharing it with your friends. Don't forget to subscribe and hit that notification bell so you won't miss any of our future content. You can also support us by donating through the thanks button at the bottom of our videos, or consider becoming a member at just 89 rupees per month.